Ray, good morning.
Good morning.
Well, we are here because you and your firm, Chandler and Jennings, you had an involvement in a historical case. It was almost a case where it was kind of unearthed, per se, and it goes back to the 40s with something that's very well known in South Carolina called the George Stinney Jr. case.
Yes.
I have a million and one questions about that, Ray, but I want to know first and foremost, what made you decide to be involved in this case?
This case was brought to me or brought to my attention, and I regret to tell you this, that I had practiced in Clarendon County for many, many years and had just heard the name, but had not looked into the details. I feel somewhat myopic about that, that had not done it.
Right.
But the case was brought to me by another lawyer who was very, very interested in getting it done. And we had then talked to a number of interested lawyers, a number of interested organizations, some civil rights organizations, some foundations that were interested in revisiting the George Jr. Stinney case.
Right.
It has been revisited numerous times since his death in 1947. He was 14 years old, the youngest person to be executed in the United States, electrocuted.
71 years ago.
Yeah.
Right.
And he was so tiny that they had to put books up under him in the electric chair to get the voltage to go through it.
Yeah.
It's an incredible thing. It's 4'7", 96 pounds. Anyway, I took an interest in it because he was tried and convicted in the courtroom where I have made my living since 1979. And it was an horrendous process. 80 days from the time he was charged, he was dead. 80 days.
Wow.
From the time he was charged, he was dead. No testimony from the defense. No witnesses put up. A 10-minute verdict after a one-morning trial. No appeal. In South Carolina at that time, we have to understand that a lot of guys were still gone because of the Second World War.
Right.
They were in transition coming back home. Segregation was the rule, not the exception. The Alderman Lumber Company, where George Stinney Jr.'s daddy worked, was a segregated facility that housed white people and black people in different neighborhoods.
Right.
Although they worked not arm in arm, but they were working for the same employer.
Right.
And so once I saw the facts and realized that there were other cases in South Carolina during this period of time, 1943 to 1949, that African American men were charged with raping a white woman, which at that point was the just the flashpoint
Right.
for the anger, hatred that welled up over race. I mean, it was just awful. There was not a rape in this case, in the George Stinney case. And those cases were tried by great lawyers, defended by great lawyers who lost, but who appealed.
They didn't have a chance.
And two of those cases where there was clearly an abduction, one of a young white school teacher down in Barnwell, they got a retrial. The case came back and was retried. They subsequently lost, but the process worked. It worked in South Carolina. It worked in Barnwell County. It worked in Columbia. It worked before our Supreme Court. George Stinney's death and execution was the most dysfunctional thing that one could ever even think would happen. I mean, it's beyond. It's
Wow.
absolutely beyond comprehension. My point was that it should have been beyond comprehension in 1947. I mean, it should have been. And it wasn't. It wasn't. And so at that point, I devoted myself, and this is the same thing that now Chandler and Jennings does.
Right.
We've got two great young lawyers, Blair and Lauren. And Lauren helped on this case in some briefing.
That's Lauren Felder.
Lauren Felder.
Right.
Lauren Felder did a great job in some briefing, in this case. But we see clients as people. We see clients as human beings. We see clients as people in distress. And there's a lot more to practicing law than taking a fee and going to court.
That's correct.
You've got to interact from the very beginning with a client, sometimes with the client's family, sometimes with the client's friends. And you've got to really delve into their backgrounds, into their psyches. And the more serious the case, and we do a lot of serious criminal work, federal court, state court. I was just telling you I had this one in Massachusetts, a cryptocurrency case, which is very, very interesting and challenging. But you've got to go back. The harder the case, the more difficult the facts, and put yourself with the client and do more than just look at the case. And I pride myself, and Blair prides himself, and Lauren Felder as well, that Chandler and Jennings does that. So the same psyche that backs Chandler and Jennings and the professional excellence that we try to achieve. And Blair, Jennings, and Lauren were at the top of their class in law school. I mean, like, there may have been 2 or 3 people ahead of them, out of 200 or 300.
And Blair definitely has that experience being a former prosecutor as well, so he can get into the mind of what they're thinking.
Absolutely.
So.
It's invaluable experience. And of course, I was a prosecutor in the JAG Corps, before I went into private practice. And so we had that. And Lauren Felder was a clerk for a judge who's now on the state Supreme Court. So we bring that. So going back to George Stinney, I realized that it was going to take more than just a tangential commitment to do it. So the problematically with George Stinney was you just could not run to the courthouse and shout, "This was wrong."
That's a great point. I have a question for you on
Sure.
that. How hard, with the case being over 70 years old, and we talked about facts, how hard is it for you to unearth a lot of these facts?
It's impossible. It's an impossibility. I will tell you, I think that we were beyond lucky. When we took it, started with it, it was dead on arrival.
Wow.
It was moribund, no matter who had looked at it. And I want you to know this. Going back to the 1800s, there are files in the Clarendon County Courthouse repository of criminal cases, almost all of them, except George Stinney's. It's missing. It ain't there. Okay. And so you go back to the state archives, and when you go back to the state archives, you find that everybody and his brother's been there looking at it. Okay. And so some of it's in cardboard boxes, some of it's, but they've looked at it and they've picked through it and, done whatever. And so going back through that does you some good, okay? But the challenge is what legal standard on which to bring it. Because in my mind, there is no such thing after 70 years as newly discovered evidence.
That's right, yeah.
There's not going to be anything.
Or new witnesses.
Yeah, new witnesses. And then if there is, you've got the passage of time that precludes any legal action under one of the appellate rules or reconsideration rules. And this is the double tragedy of the Stinney case. Let's look at it this way. And this is what Blair Jennings said when he and I were consulting, on it. Blair said, the good news is that we know that there are things that weren't presented, right? The bad news is the legal standard is if you knew or should have known at the time and did not present it, you're precluded from arguing it later. There was no statute at the time for failure, inadequacy of counsel. And that may be a story for another time, but there was a political reason that the lawyer that was appointed to Stinney, who was a young lawyer with political aspirations, was appointed.
Well, he wanted to probably make an example at that time or make a name for himself.
Well, he wanted to make a name for himself politically, but not as the lawyer for George Stinney.
Understood.
Right? That's the difference in Chandler and Jennings and that lawyer. We aren't in politics. Okay? And if we have to take a case, we're going to take it and it's going to be 150%. Politics be damned.
Right.
So if you're starting to peel the onion as to whether your vision in the community is going to be changed or altered, you shouldn't take the case.
That's right. I agree.
And Chandler and Jennings makes that decision before the client gets put at risk. We would just decline it if we thought there was any hope that we would be circumspect in a way that did not protect the client's best interest.
Now, I want to paint the picture for a lot of people because I remember being online one day and I would see the image pop up, just out of nowhere, just web traffic. But I went through, as I knew we were going to discuss this, and Blair Jennings and I had this discussion about the Stinney case. Just painting the picture. This was 1944, Clarendon County. 47, Clarendon County. There was like a railroad track that kind of separated the people. The whites lived on one side, and some of the blacks lived on one side. And these two young girls, they went picking flowers,
looking for maypops.
Looking for maypops. George was walking, I believe, with his sister.
George and his sister, after school, their job was to take the cow out to graze, because they had a cow. They had chickens, what have you, in this tiny
it was more common
house
around this time.
Yeah. And so they were, I think this was in May, late April or May. And so they were out there grazing the cow. And you can imagine, a 14-year-old kid out there with his younger sister, probably bored to death, at wanting to do that, right? And absolutely, there was a railroad track that was a spur line because Alderman Lumber Company, which was later Georgia Pacific, owned by Georgia Pacific, was processing wood, and that they would use that spur line to get to the main track. So it was out there. And so I'll paint the picture for you. These two girls were, I think, 11 and 8. The older girl was named Benneker, and the younger girl last name was Timms, and the older girl had a bicycle, and they were walking with the bicycle nearby this grazing area. And as the account was given, and these are newspaper accounts, not testimonial accounts, was that Ms. Benneker, the Benneker girl, asked the two Stinneys if they knew where there were maypops. And apparently we're told that there may have been some, there could have been some down this road. It was a country road. And it was a distance from maybe an eighth of a mile, a quarter of a mile from the community where the Alderman Lumber Company was, which is which was called Alkaloo. Alderman Lou Lumber, okay, Alderman Company Lumber,
Okay.
AC, that's ALCOLU, okay. And so the girls left, and they didn't return home for dinner. And so there was, within hours, less than hours, there was search parties organized. People were looking for them. And African American people were in the search party. George Stinney's daddy was in the search party. And that night, they searched into the night and did not find these children. But in the course of it, they were asking questions. And
in the course of the search.
In course of the search, investigation, people were asking questions. And George's Stinney's sister had told the mama, and the mama had told the daddy that George and his sister had seen the two girls that afternoon.
Right.
And they left with the bicycle. So now I've got an 11-year-old, an 8-year-old, and a bicycle. Okay. And I've got a 4'7", 96-pound, diminutive, frail young man.
That's very small.
Okay,
very small.
Very, very small. Now, you think about that in terms of what the average 11-year-old weighed, and I did that research, by the way. Actually, Lauren Felder of Chandler and Jennings did that research because she's OCD. And
I won't tell her.
No. So she did the research, and she comes to me and she says, Ray, look at the Department of Agriculture statistics of what the average woman, young woman, child at 11 is, and it's 78 to 82 pounds. So this child was probably just an inch shorter or the same height as George Stinney and weighed 12 or 13 pounds less. And then there was an 8-year-old and a bicycle.
Yeah.
So the next morning, they were found by a search party, and they were found together with the bicycle, okay, laying side by side. And we got a call from a minister in Missouri while we were working up this case that said, I heard the news that you were working up this case. I was in the search party.
Get out of here.
And we said, what? And he said, yeah, I'm 75 years old, but I was 15 or 14 then, and my daddy let me go. And I went with my daddy on the search, and he was talking about the facts of it. And I don't know that he believed, as he heard it, that he was giving the defense assistance. I think he was recounting, the facts. So that morning, they were found in a low area. Some reports say a ditch, some say a low area, but it was holding water,
Okay.
in that area. And the bicycle. So now you've got the challenge for this diminutive, tiny George Stinney Jr. at 14 to overcome and murder 2 women. Okay. Leave the cow.
Ditch his sister.
Yeah, ditch his sister. Overcome and murder 2 women, right? Then drag them or carry them both to this ditch and the bicycle. Just doesn't happen.
Yeah.
So, at any rate, this person came forward. And that gave us some spark. So let me get back, please, if I could,
absolutely.
to the point. So our issue was how to get this in front of a court. Because if we brought the matter as newly discovered evidence, right, then it wasn't newly discovered, or it should have been discovered at the time. But what we uncovered, and Matt Burgess did this, one of the lawyers who was working with us.
Okay, I remember him from the reports.
Yeah, although they said that Matt did an incredible amount of work on it, Ray Chandler paid all the experts out of his pocket. Ray Chandler found the experts, Okay, and Ray Chandler did all the depositions. Okay, Steve McKenzie helped try the case and did a great job. Okay, but I hate to sound like I'm being selfish and taking credit for this, but had it not been for that, we would be, George Stinney would still have a conviction. So here is how we found the autopsy report. Matt Burgess found the autopsy report at the archives. And the autopsy report in and of itself was somewhat vanilla, right? But it's got a great story behind it, okay?
Yep.
And this is the great story. The autopsy was done by a country doctor who was a legend in Clarendon County, A.C. Bazard, okay? And Dr. Bazard had come to Manning to take over a doctor's practice. And it was Dr. Bazard and his nurse, and he subsequently married his nurse. Okay. And they were husband and wife and practiced medicine together. So Dr. Bazard obviously was one of those that took the bag into your house, right? Delivered babies.
Right. Came with a medical bag. He's the
black
guy.
Babies, white babies, he was Dr. Bazard, right? And so he did the autopsy himself. Mm-hmm. And another doctor, whose name eludes me, from Sumter, signed off on it because both of them had to sign it. Okay?
Was that law or?
Yeah. They had to sign it. However, in the trial, apparently Dr. Bazard had a cold. And the other doctor who didn't perform the autopsy testified.
Not the one that signed off.
Yeah, the one that signed off, but had not done the autopsy.
He was there.
Correct.
Got it.
So remember that this was the murder weapon. Forget there was no motive in this case, other than George Stinney Jr. was just a mean little son of a gun.
Wow.
Right? Does that make sense? So,
wow.
So a mean little 14-year-old son of a gun kills two complete strangers who happen to be female. So the theory was it was sexually related, motivated. Okay. Well, the autopsy did not show that there was any sexual molestation at all. Okay. Of the 11-year-old, obviously we would not think of the 8-year-old.
Yeah.
The autopsy report showed very few scratches or abrasions on the children. The autopsy report showed no evidence that those bodies had been dragged anywhere, because what you would have seen then was bruising or something on the backs,
debris or anything on their bodies,
their
right?
legs. Okay, and there were no ligature marks on their arms for being tied or bruising from being dragged, which you would normally see when the blood, had stopped. Mm-hmm. You might see that. Very little. This guy who called in, there was no blood at the scene. But when they found the two kids, there was little or no blood around the scene, which meant that the thing had happened somewhere else. Now,
wow.
You get to the autopsy report, and this is when Blair and I look at it. And I studied that thing. And I called a forensic pathologist who was Canadian, had retired in North Carolina, and testified for me in a case, a baby death case, maybe 7 or 8 years before. His name was Dr. Peter Stevens. And I sent Pete the autopsy report and the facts surrounding it, okay? And he called me. He's got that Canadian, British, type voice. He calls me about 3 days later, and he said, "Ray, these two children were beaten to death." And I said, "No joke, Doc. What else can you tell me?" He said, "It wasn't a railroad spike." And I said, "Well, the detective, the policeman, said that Stinney confessed to him and led him to the railroad spike."
But from what I understand, he was coerced.
Well, that's another part of the story. Okay, it's another part of the story where we brought in Dr. Amanda Salas, and that was the most serendipitous thing you can ever imagine. But if you don't mind, I'd like to.
Absolutely.
So I said, so what do you think did it? And he said, well, if you look at Dr. Bazard's report, he tells you it wasn't a railroad spike. He said the indentions were rounded like a hammer. So these children, we believe, Dr. Stevens believes, were killed with a ball peen hammer, with the rounded part of the ball peen hammer. Okay, he says that because A, the indentions would be very similar. They're under the size of a quarter. Okay. 2, the hammer handle would give you the leverage that you needed
to be able to swing it.
To inflict that. And so if you say, well, George Stinney used a 4 to 5 pound railroad spike. Okay, railroad spike would be about 8 or 9 inches long. It's heavy, and it's square, right? So Stinney would have his little hand around the railroad spike at some point, right? And now with his height, how is he going to get to the top of the head of this woman who was about his height to crash her skull? And what the heck was the second person doing while he was doing that 4 times? They'd be running. They'd be running. And could he run them down and without any ligature or anything else then get to the top of her head? It's ridiculous. So that was the spark that gave us the idea that we were going to win this. Okay, we were going to win this.
Right.
Okay. Because they can bring every railroad spike, and there are probably 6 or 7 different types of railroad spikes. But if you walk down a railroad right now, they pop up all over everywhere. I bet if you and I walked 200 yards of a railroad right now, we'd come back with 6, right?
Yeah.
And so then you got to figure out what was George doing with a railroad spike out there with his sister and the cow. Like, oh, I think I'm going to kill somebody this afternoon, therefore I'm going to take this railroad spike with me. Anyway, so the bicycle that was found had been broken. Okay, we think something with the tire, with the wheel. We believe these girls got picked up in a car. Okay, we believe the individual who picked them up took them back to his house and was, quote, working on the bicycle, right? Girls were distracted. He came up behind them with the ball peen hammer and murdered both of them.
And he probably knew them.
And then he was able to put the girls and the bike in the car trunk and take them somewhere and carry them, because he was a big guy, right? And carry them, he wasn't 96 pounds, and carry them and place them, and then carry the bike. So, having said that, we had the next problem to get over, and that was what you mentioned earlier, was the confession. Okay, and the confession was not written down. It was not signed by George Stinney or anyone else. It was orally recounted, in the trial. And so, George and his brother were arrested, taken out that next afternoon late after the girls were found that morning, early that morning. George's mother, father, and sisters left Alderman Lumber Company and went to Sumter area, Pinewood, never returned. So they were not available at the trial. The brother was later released, and 2 policemen rode him back out toward Alcaloo, stopped at a stop sign, and threw him out of the car on the ground. At which point he walked away from Alcaloo, found somebody to put him up for the night, and within a month had joined the Army and never returned. So End of story. We now have a confession. The brother was not in the room. The parents were not called, right? And you have then the Gideon versus Wainwright issue that you have to start into. And remember now, we're 1947, and the 14th Amendment had not been so strictly applied by the federal government, because it was not until the 60s that you had the Earl Warren Court that started doing all of these things with confessions and evidence and searches.
Okay.
Right? So now we have a case that has to, so you have to say, how do you couch this case? Okay? It wasn't a Fourth Amendment case because it wasn't a search, right? But it's clearly a Fifth Amendment case, right?
Right.
And it was clearly a Sixth Amendment case, okay? Because the entire method of the trial smelled, all right? So it hit me that, and this is one of the experts that Chandler and Jennings uses, okay? This is a Chandler and Jennings expert, and she's my buddy. Her name is Dr. Amanda Salas. And I had been using another forensic expert psychiatrist from Columbia, but she had gotten engaged and was trying to get out of the business.
Okay.
So when I called her, she said, I want you to go see Amanda Salas. And I said, okay. And, you know, so now in South Carolina, you're thinking Salas. Now, what am I got? I got a Greek name for somebody. I like Smith. Quite frankly, you know, I just don't like to confuse juries or something with somebody from out of town.
Right.
Right. So and now I know I got a Canadian, right? I'm looking for some homegrown.
You got the Canadian in North Carolina.
I'm looking for some homegrown help. And so I got Amanda Salas's name, and I called her. Now, remember, Chandler and Jennings uses her now. She's on 2 cases for us now. And she is a very lovely, blonde-headed brewer. That was her maiden name. Guess where she was from? Manning.
Manning, South Carolina.
She is an adolescent, child, and adult psychiatrist, qualified in all 3 forensically. And do you know what her qualification paper for her child psychology was? George Stinney.
So she was versed before she got the call.
When I called her and I said, I'm calling you to help me out in a case, and she said, what's the case? And I said, George Stinney. Her words were, oh my God, I never thought I'd get this call. And from then on, we bonded. And so we had a third part of the puzzle. Third part of the puzzle, remember, was how to get into court.
Right.
So Lauren Felder called a former professor of hers, a very well-known professor, Miller Sheely, who's a criminal law professor at Charleston School of Law, and asked him if he would look into it. And then Steve McKenzie followed up, and I credit Steve completely with getting Miller into the case and prepped up for the case, etc. Steve did a fantastic job with him. Miller decided that we did not have a present-day Rule 50, or other rule to stand on for newly discovered evidence. But there's an old common law writ, and South Carolina still uses the common law. So the old common law writ in England was a writ called coram nobis. And coram nobis, the Latin term, there's an era before us, okay? And so it would be the plea made if there was no other remedy, but the result in the trial was so unjust that it begged for a remedy.
Wow.
All right?
Wow.
And so there's some smoke and mirrors in coram nobis, my friend. All right? It would be one of those that the court could say yes or no.
They could allow it or not allow it.
Right,
Right.
right. They could say, nice try, buddy, but, good try. Well, it was all we had, right?
It was your wild card.
So we had Miller now, right? We had Dr. Peterson, and we had Amanda Salas, right? So we had all the bases covered, but we wanted to show the unjustness of it. So I went up to New York and took the deposition of George's older brother, who was 79 years old, went to Brooklyn, one of the nastiest deposition rooms I've ever been in. And I took the video deposition of this gentleman who had had a stroke. I had to pick him up at his house. I had to drive him in a car, to the place, get him upstairs, sit him down, feed him, and then get him to do the deposition, which was one of the most awful depositions in the world because I led him like a lamb.
Yeah.
Would not have been allowed to do that in any courtroom anywhere. But he told the story, was able to tell the story. And then we paid the way for his sister, who was in good health, the younger sister.
She was 77, I think, at the time.
Come to court, and she was a good 77.
Mm-hmm.
Come to court in South Carolina, where we tried it in Sumter.
Mm-hmm.
Now, here's the picture now. This is how it all comes together. I've got an African-American prosecutor in Ernest Finney, Jr., whose father was my dear friend, was the first African-American circuit judge. I tried his first criminal case in Manning. I was the defense lawyer. And he was the first African-American on the Supreme Court and Chief Justice of the Supreme Court. He was the prosecutor, okay? And these white guys were the defense. Does that make sense?
That's a turn of events.
And now I got a female judge, all right? And so I'm liking all of this. I'm liking all this. And then from out of the woodwork, after we'd spent all of this money and all of this time, here comes CNN, here comes 2020, here comes NBC, here comes Fox News, wanting every piece of us, right? Wanting every piece of us. And they were wonderful, but I had told the Steny family that we would not bring a lawsuit. Chandler and Jennings would not do this for money. That has changed now with my former firm and the Charleston School of Law, who are bringing a big lawsuit. And I would have no part of it. Because I told those people they had been promised money, they had been promised everything for their story for years and years and years, and led down the road. And I told them when I talked to them, we're not bringing a lawsuit.
Right.
What we're doing here is making this right. Okay, so
that means everything.
I mean, that's, you can't do this for money, all right? You do this because it's right. It cries out, okay? So we try it for 2.5 days, and I did Dr. Peterson, by deposition. I went up to Asheville and did it, okay? And he was great. I mean, he was fantastic. And I did Amanda Salas. I worked for 5 days with her on her testimony. And her testimony was basically that there was no way, now think about this, there's no way that a 14-year-old African-American preteen has connected anywhere in his life with a white male adult. He just doesn't know it. 1947, where would you come in contact with him? You at the company store, that's where you were. I mean, you didn't have a car.
Right.
Right? Now, add a white male adult, right? That was 45 or 50. Add a white male 45 or 50-year-old adult with a gun on him. Add a white 40 to 45, 50-year-old adult male with a gun on him, in a tiny room in the police station. And you think this kid gave a voluntary confession?
Exactly.
Okay.
Exactly.
And so we don't know how long he was in there. We don't. But Amanda indicated without a doubt, that the psychological impact of that change in environment and the fact that these people were making the accusations, that no matter how it was done, it would not come out.
Because around that time, if a 14-year-old, if he ever did come in contact with him at the store or wherever, because a lot of things were segregated, remember?
Correct.
It was more of a yes, sir, kind of mentality then.
It was more than that. Being 70 myself,
mm-hmm.
and being raised in North and South Carolina during the 50s,
mm-hmm.
right? A black man would not look a white man in the face, would not make eye contact. They would turn their head down. And you see that now in Hispanics.
Wow. Ray, you just said back then a young black kid, he wouldn't look, he wouldn't make eye contact.
And a black male, right, regardless of their age, would not make eye contact. And so we had there's a thing where you are interviewing someone that has in a deferential position
mm-hmm.
to you, right?
Mm-hmm.
You have to be very careful with their body language,
right?
Because you'll see them look away or look down, right? And it's not because they're looking away or looking down, particularly because they're lying. It's just that your visage is something that strikes them as looking at you as disrespectful.
You made a comment just now when we went to break. You said it's fixed.
It's fixed.
This is what South Carolinians do. We make it right.
They do.
Brought up Mother Emanuel, and we all know about that and what happened there in June. Do you feel like people, especially like some young black youth, do they get a fair trial today?
The difference in trials today and trials in the 40s or 50s is not apples and apples. In South Carolina today, there is a significant amount of effort that is put on getting it right. The inequity in our system nationally, I don't think has to do with race
mm-hmm.
as a whole. I think it has to do with money. I think you get a better trial in some cases if you can pay for it. I think you get a better lawyer if you can pay for it, a more experienced lawyer. Does that mean that a lot of public defenders aren't fantastic lawyers? I mean, you look at the Jack Swirling who defended Pee Wee Gaskins.
Mm-hmm.
You know, Jack was just starting out.
Pee Wee Gaskins, that was in the 80s.
Yeah.
Wasn't it?
Yep. But I mean, those were not paid lawyers.
Right.
So I can point to you tremendous examples of wonderful young lawyers who are PDs. So the answer to you is no, I don't think the unfairness is along racial lines.
Mm-hmm.
I think the reality in a lot of cases, state cases, is that without the financial wherewithal, there is a difference. It may be a subtle difference.
Right.
What I do see, however, is on the whole in South Carolina, and I've tried some cases in Georgia. I've always said if I had a brother in jail and one in Georgia, I'd get the one out of Georgia first. When you see, tried them in North Carolina, mm-hmm. right, that the prosecutors now are fair. Even the toughest ones That's the fairness.
Yes.
Okay. So now we come to the last element in that, and that is the police. And we talk about, this has been in the news a lot. The bias in the George Stinney case was a racial bias,
Right.
but it was a cultural bias then. I'm not excusing that, but that's how it was.
That's how it was back then.
Right, how it was. If you applied that bias to 2018, that would be horrific. That doesn't exist. That doesn't exist. Do law enforcement people make mistakes? Yes. Do they lie? Yes. Okay. Do they step over the line? Yes. I see it every day. Okay. But they do it notwithstanding the racial. I see them do it to Hispanics on I-95. I see them do it to other things. What's it about? It's about laziness. It's about the abuse of authority, right? It's about the position. And just in every walk of life, I know you see it, the wrong people get in the wrong jobs. When they do, they're going to do the wrong thing. And then some people just make mistakes. They aren't doing it because of bias. They just make a mistake. They screw up. What frustrates me a lot in 2018, after giving almost 5 decades to the defense of people, okay, is that everything that is a mess up that involves an African American and a white person is racial. Is that not just a mess up, right? And then if you've got the wrong person in the wrong job, then you color the entire department or the entire police force with racism. The brush is too broad.
Right.
Does that make sense?
It does. It makes
and it's in the reverse too, right? It's in the reverse. I would be a fool not to tell you that I think there are a bunch of white people, right, that don't see somebody who's committed a crime, right, and say, "Oh yeah, blacks are like that," right? Well, what has happened? We've created a culture over the last 50 or 60 years where in the large cities of this country and some of the large cities of this state, where we have, in effect, in order to advance the well-being of African American people, we have placed them in a segregated George Washington Village type of environment, where they're not dads, that grandmothers and great-grandmothers are,
mom and dads
are raising the children, right? And the drugs are in the street, everywhere, and the guns are in the street everywhere. And so if you've got a higher crime rate among African Americans because of that, that means that this system has failed to enfranchise those people, and should not be a broad brush then that culturally, right, that people have more proclivity to commit a crime.
Right.
I'll show you some people who are Caucasians, right, that I don't want to be in the same room with them.
Right.
I mean, there ain't enough armament that I can put on me.
Right.
So I digressed a little bit, but here's how this is fixed, okay? This is fixed because people, whether they're of color or not, people are human beings. And tragedies such as the George Stinney case strikes your heart.
Absolutely.
Both of our bloods are red. Our hearts work the same. And our devotion to doing the right thing is similar. And so George Stinney gets fixed because the lawyers at Chandler and Jennings decide that it had to be. The Steve McKenzies, the Matt Burgesses, decide that it has to be. That judge went out on a huge limb. She has been criticized for this because people, just from a procedural standpoint, not a racial standpoint, didn't want everybody coming up from 80 years
Got
and
it.
bringing these cases. She was heroic. Amanda Salas was fantastic. And I have to tell you that she has presented nationally. The National Association of Psychiatrists has invited her to present there.
That is so interesting that she wrote her paper on the George Stinney
Isn't it?
case.
And so,
Gosh.
why did we fix it? You asked me why I did this, because it had to be, right? And I will tell you that if somebody that God had not blessed with money, and that God had not blessed with the talents He has given me that I do not deserve, and not the ability to associate with people of the character of Blair Jennings and Lauren Felder, it wouldn't have happened. Just think of the connections that we had.
Well,
You know who one of the greatest fans of the George Stinney case was?
who's that?
Dr. Bazard's son, who recently passed away. But he would come to my office and sit and talk about what his daddy did in that autopsy report.
Wow.
That kind of gives you the background and the depth of this.
It pulls on your heartstrings.
It does.
And I will say this, and we'll end it here. This had to happen because it had to be done.
Yes.
And I want to say thank you for fixing it. Thank you for going back in time and doing what was right in history.
Thank you, sir.
Thank you. Ray, man, man.